Yes. हाजिरी लगा देना. Yes. Yes. Now, my lords, before we proceed on the position of law, my lords, it's important to note few dates in the case, my lords. Yes. My lords, in this case, the advertisement was issued on 24/11/2021. Yes. Which, my lords, I read on 24/11/2021. Yes, my lords. Yes. The last date of filing this application form in pursuance of this advertisement was 31/12/21. Last date of application. That was 31/12/2021. That is on page number 26, my lords, would find. Which was further, my lords, extended to 2/1/22. 2/1/22. Yes, my lords. Yes. So before the last date of an application form, my lords, a corrigendum was issued. Corrigendum was issued 15/12/21. Yes. Which was impugned in the writ petitions, my lords. Before last date. 15 days before the last date of filling of an application form, wherein the state government took a decision that it is the degree holders are also eligible to apply for the said post, my lords. In pursuance of that, my lords, an examination was conducted on 12/2/2022. 12/2/2022. Result declared. The result was declared, my lords, on 6/4/2022. Yes. Result was declared, my lords, on 6/4/2022. Yes. And then, my lords, the equivalence report, which is on page number 637 of a writ petition, my lords. Yes. My lords, that my lords would see that is by virtue of was filed by virtue of additional affidavit, my lords. Yes. वो तो जजमेंट में भी कोट कर रहा है. जजमेंट में भी कोट है, my lords. That was जजमेंट का बता दीजिए. इक्विवेलेंस रिपोर्ट अवेलेबल एट पेज नंबर. At running that is at page 15 of the judgment. The opinion of the DOP and the equivalence report is starting from page number 15 of the judgment, Your Lordship. Don't interrupt in between. Don't interrupt. Counsel is arguing. Don't interrupt. Yes. I'm just assisting to the effect, Your Lordship, with regards to the equivalence report. It's the assistant, Mr. Meena is Ajay Shatru is in a better position than you to assist the court right now. Yes, Oblige, it's on internal page number 15 of the judgment. Manoj would find initially the order which was passed by DOP is in 30/8/2022. Equivalence report, my lords, is on page number 17. No. First, the order was passed on 30/8/2022. Then the learned single just passed the 14/10/2022. Yes, 14/10/2022 is on page number 17. Internal page number 17, my lords. 17 of judgment, huh? Yes, my lord. 17 of judgment. Yes. Now, one most important factor, my lords, which was also considered by the Honorable Chief Justice while passing an interim order, that prior to this, my lords, the advertisement of 2013 was there, wherein also the same situation came and the state government took this decision, my lords, would see, my lords, on 4/9/2015. Judgment में बताओ जो फाइल में है वो डॉक्यूमेंट बताओ आप. This notification was referred, my lords, would see for a moment the interim order. Yes, interim order में बता. My lords, see, kindly have a look at the interim order for a moment. Yes. May I read, my notes, page number 5? Yes. We find that the learned single judge. Yes. This is order dated. We find. Yes.
We find that the learned single judge has allowed the writ petitions directing exclusion of a degree holders in automobile mechanical engineering, holding that though degree in automobile mechanical engineering is higher, it is not prescribed qualification in the advertisement and the rules. Therefore, candidate possessed of degree in automobile mechanical engineering cannot be allowed to apply and participate in the process of recruitment for the post of motor vehicle sub-inspector. Moreover, it is also found that though the learned single judge has passed an order directing the state government to draw the equivalence, the same has not been taken into consideration while deciding the issue. On the basis of that, courts cannot draw equivalence. There is considerable force in the submission of learned counsel for the appellants that issuance of corrigendum dated 15/12/2021 was essentially based on letter dated 4/9/2015, my lords. This is exactly what I was giving to my lords.
Yes.
Issued by Joint Secretary, Department of Transport, Government of Rajasthan, wherein it was clearly provided that degree holders in the relevant subject would also be eligible, and further taking into consideration the view of the Honorable Supreme Court in the case of Jyoti KK and others versus Kerala Public Service Commission, we are of the view that it is necessary to protect the interest of all parties and preserve status quo till final decision of the present appeals.
Yes.
Therefore, my lords, I was referring to this notification of 4/9/2015, my lords, and which plays quite an important role while deciding these appeal also, my lords.
Yes.
Because the submission is this, my lords, that this has been the consistent stand of a state government that the degree holders will be eligible to apply for these posts. My lords will kindly see. This was with regard to the advertisement of 2013. विषय मोटर वाहन उप निरीक्षक प्रतियोगी परिषद 2013। महोदय, उपरोक्त विषय अंतर्गत प्रासंगिक पत्र के क्रम में निवेदन है कि मोटर उप वाहन निरीक्षक पदों की भर्ती हेतु आयोग द्वारा जारी विज्ञापन 6/8/13 में निम्नानुसार निम्नलिखित तकनीकी योग्यता वांछित है: a diploma in automobile engineering 3 years or a diploma in mechanical engineering awarded by state government, any qualification in either of the above discipline declared equivalent by the central government or state government. The state government answer, बिंदु संख्या 1 के संबंध में न्यूनतम योग्यता 3 वर्षीय डिप्लोमा से उच्चतर योग्यता अर्थात डिग्री धारकों को उक्त पदों हेतु पात्र माना जा सकता है. On the basis of this decision taken by the state government, my lords, the previous advertisement was taken place in 2013, and therefore in 2021 when the advertisement was issued, my lords, a clarification was issued, my lords, way prior to the last date of an application form, that even those people who possess a degree, they will be eligible to participate in this examination, my lords, and accordingly they participated. Now, my lords, kindly see the position of a rule for a moment, my lords.
Now wait. Yes. Yes.
So, initially, my lords, when the Motor Vehicle Act 1988 was enacted, my lords, kindly see on page number 68 of a writ petition.
Page number
68.
yes.
The language of this section is quite important, my lords. May I read, my lords?
Page number
68, 68.
yes.
This is the original pretext of the section which was existing in 1988, my lords.
Yes.
Minimum qualification for inspector and assistant inspector of motor vehicles dated 12/6/1989. In exercise of the powers conferred by subsection 4 of section 213 of Motor Vehicle Act 1988, the central government hereby prescribed that the minimum qualification, now this is important, my lords.
Yes.
Central government hereby prescribes that the minimum qualification for the class of officers consisting of the category of inspector of motor vehicle or assistant inspector of motor vehicles shall be as under. Qualification: 1. Minimum general education qualification of pass in 10th standard, a diploma in automobile engineering 3 course or a diploma in mechanical engineering awarded by the State Board of Technical Education, and 3. Working experience of at least 1 year in a reputed automobile workshop which undertakes repairs of both light motor vehicle, heavy goods vehicle and heavy passenger motor vehicle fitted with petrol and diesel engine. 4th, a must hold a driving license authorizing to drive motorcycle, heavy goods and heavy passengers motor vehicle. My lords, this section stood amended, my lords, in 2009, my lords, 2019. Now, my lords, may I read the amended portion?
Yes.
That is there in the bare act, my lords, of Motor Vehicle Act 1988. And I am taking, my lords, to Section 23 sub 213 subclause 4.
Section 213 subclause 4.
My note. Section 213. The subject matter is appointment of motor vehicle officers.
Yes.
And I want my lords to have a look at clause number 4 for a moment.
Yes.
The central government may, having regard to the object of the act, by notification in the official gazette, prescribe the minimum qualification which the said officers or any class thereof shall possess for being appointed as such. So, what the mandate of section 213 subclause 4 is that the central government will prescribe the minimum qualification for that.
Yes.
And my lord, what was the minimum qualification prescribed by the central government is on page number 69. Page number 69, my lords, the notification of 8 March 2019, and my lords would find the relevant portion on page number 70.
Yes.
May I read, my lords? In exercise the power conferred in subsection 4 of section 213 of the Motor Vehicle Act 1988, the central government hereby makes the following amendments in the notification of a Government of India in Ministry of Transport, Highways published in the said notification under the heading qualification for serial number 1 to 4 and the entries relating thereto the following serial number entries shall be respectively substituted, namely 10 standard pass from any recognized board, a diploma in automobile engineering 3-year course, a diploma in mechanical engineering 3-year course awarded by any institution recognized by central government or a state government, and holding a driving license authorizing in drive motorcycle with gear and light motor vehicle, my lords. So my humble submission is this, my lords, was central government, and as per the mandate of Motor Vehicle Act 1988, the mandate was that the central government can prescribe the minimum qualification. And this minimum qualification, my lords, is also reflected in the rules of 1963, which is on page number 156.
Now, this advertisement has been issued in pursuance to the 79 rules?
In pursuance of 63 rules. These rules, my lords, I was reading with respect to
Rajasthan Transport Service Rules.
Rajasthan Transport Subordinate Service Rules 1963. Subordinate Service Rules, and my lords would find those rules at page number 156 of a writ petition. 156.
Yes, 156.
156, my lords. And my lords, without wasting my lords' time, I'll take my lords directly to the schedule 1 at page number 178.
170?
178, my lords.
Yes.
Now, in 178, my lords would find the entry number 2, motor vehicle sub inspector.
Yes.
25% by promotion, 75% by direct recruitment. Must have passed secondary examination of recognized board. Second, a diploma in automobile engineering 3 years course, or a diploma in a mechanical engineering awarded by the state government of technical education, or, now this is important, my lords, any qualification in either of above disciplines declared equivalent by the central government or the state government. Now I'll pause here, my lords. It is only with respect to the minimum qualification when a central government and the state government declared equivalence. This is a case of a higher qualification, my lords. This is a case where the state government has taken, in his own wisdom, my lords, has taken a call that those people who possess a higher qualification, my lords, of the subjects
any qualification in either of the above discipline
declared equivalent of central government or state government.
But higher is not mentioned in the rules.
Higher is not mentioned. That is, my lords, because this is vis-a-vis the minimum qualification. The section 213 subclause 4 also mandates, my lords, that a person should have a minimum qualification. A state can always prescribe a higher qualification, my lords, and that was also laid down by Honorable Supreme Court, my lords, in the case of Satyapal Reddy versus Government of AP, 1994, 4 SCC, my lords. Same subject came with respect to 213 subclause 4. The judgment is also part of a writ petition on page number 182, my lords, wherein the same issue came up. The Honorable Supreme Court says that the 213 subclause only prescribe the minimum qualification. It is the domain of a state government to prescribe a higher qualification. A state government cannot go below the qualification prescribed under the Act. However, the state government has the power to go beyond that, my lords. And that is precisely what has happened in the in-state case also, my lords.
In a judgment related to the class 4 employee recruitment, where the Honorable Supreme Court has opined that minimum qualification prescribed or what have been prescribed in the advertisement. Persons having higher qualifications are not entitled.
Manoj, I'll just submit
With
for a
regard to case, I think related to Punjab National Bank. Class 4.
Qualification was well.
Yes.
The person who was graduated, they applied.
Yes, yes.
It was an important fact that the person, he concealed this fact that he was graduated. Therefore, it was specifically observed that persons having much higher qualifications, graduate,
They are not entitled.
yes, these were not exclusive degrees.
Yes.
And after that, Manoj, we'll read to that judgment also. After that, Supreme Court has considered Puneet Sharma case on Honorable Justice Ravinder Bhatt has considered these aspects, and he has said again that the prescribing a higher qualification is a domain of a state government. In this case, Manoj, what has happened? I'll submit for a moment. These prescribing of a higher qualification is part of an advertisement, Manoj. Nothing has been done after the game has begun.
Where is the in the original advertisement? It was
Original advertisement, corrigendum was issued, Manoj, right after 30 days of a advertisement before the last date of an application form, Manoj. The last date of application was 13/12. This notification, corrigendum, was issued on 15/12.
Yes.
So, Manoj, kindly have a look at page number 182 for a moment, Manoj, with respect to the power of a state government of prescribing a higher qualification.
Yes.
And Manoj, I'll take my notes to page number. This is page number 182, 1994 SCC 391.
Yes.
And I'm taking my notes to para number 7 of this judgment on page number 186.
जजमेंट इसकी अपील का पार्ट बनाते हो, कोई लिखने से नहीं रह जाए हमारे से, इसको या फाइल मोटी करने में कोई इसका बेनिफिट मिलता है?
No, this is only for the convenience of honorable court, Manoj.
कन्वीनियंस क्या, हमारे पास लाइब्रेरी में किताब है, आपके पास है, हमारे पास है, ये इतना बल्कि रिकॉर्ड बना देते हो, आपके फाइल उठाते ही कंधे दर्द करने लग जाते हैं पियोन के. Yes.
So I'll take my notes to page number 186 for a moment.
जजमेंट जो आप रिलाई करते हो लिस्ट बना के दे दीजिए, निकाल देंगे, वो सारी निकाली पड़ी है, इससे बताओ आप. तो
This is
आपने दी, चलिए बताओ.
1994 SCC
Yes.
391.
Yes. Yes. Which para?
Now, Manoj, I am taking my notes to para number 7.
Yes. Yes.
It's little lengthy, Manoj. May I read it from? It is thus settled.
Yes.
May I read, Manoj, from para
Para 7.
It is thus settled law.
Yes.
It is thus settled law that Parliament has exclusive power to make law with respect to any matters enumerated in List 1 or concurrent power of the state legislature in List 3 of the 7th schedule to the Constitution, which shall prevail over the state law made by the state legislature exercising the power on any of the entries in List 3. If the said law is inconsistent with or incompatible to occupy the same field, to that extent the state law extends superseded or becomes void. It is settled law that when Parliament and the legislature derive that power under Article 246 subclause 2 and the entry in the concurrent list, whether prior or later to the law made by the state legislature, Article 246 subclause 2 gives power to legislature legislate upon any subject enumerated in the concurrent list. The law made by Parliament gets paramountcy over the law made by the state legislature unless the state law is reserved for the consideration of the President and receives his assent. Whether there is an apparent repugnance or conflict between central and state laws occupying the same field cannot operate harmoniously. In each case, the court has to examine whether the provisions occupy the same field with respect to one of the matters enumerated in the concurrent list and whether there exists repugnancy between the two laws. Article 254 lays emphasis on the words with respect to that matter. Repugnancy arises when both the laws are fully inconsistent or are absolutely irreconcilable and when it is impossible to obey one without disobeying the other. The repugnancy would arise when conflicting results are produced when both the statutes covering the same fields are applied to a given set of facts. But the court has to make every attempt to reconcile the provisions of apparently conflicting laws and court would endeavor to give harmonious construction. The purpose to determine inconsistency is to ascertain the intention of Parliament, which would be gathered from the consideration of the entire field occupied by the law. The proper test would be whether effect can be given to the provisions of both the laws or whether both the laws can stand together. Now that is the line after this is important, my lords. Section 213. This judgment is also regarding the Motor Vehicle Act 213, Manoj. Section 213 itself mandate that the distinction of the power exercised by the state government and the central government in working the provisions of the Act. It is the state government that operates the provisions of the Act through its officers. Therefore, subsection 1 of section 213 gives power to the state government to create transport department and to appoint officers as it thinks fit. Subsection 4 thereof also preserves the power. By necessary implication, it is also preserve the power to prescribe. Now, this is important, my lords. Kindly note this, my lords. By necessary implication, it also preserves the power to prescribe higher qualification for appointment of officers of the state government to man the motor vehicle department. What was done by the central government was only the prescription of minimum qualification, leaving the field open to the state government concerned to prescribe if it finds necessary higher qualification. The governor has been given power under provision to Article 309 of the Constitution, subject to any law made by the state legislature, to make rules regulating the recruitment, which includes prescription of qualification for appointment to an office.
Under Article 309.
Under Article 309.
Where is the qualification prescribed, higher qualification prescribed under Article 309?
No, Malaj, I'll go further, Malaj, what it says.
Yes.
Since the transport department under the Act is post belong to the state government service, while appointing its own officers, the state government as a necessary adjunct is entitled to prescribe qualification for recruitment or conditions of service.
Yes.
But while so prescribing, the state government may accept the qualification or prescribe higher qualification, but in no case prescribe any qualification less than the qualification prescribed by the central government.
Well, the state government can prescribe higher qualification, but that should be included in the schedule.
The state government, my lords, has taken a call by its own wisdom, my lords, as I was reading the circular of 4/9/2015, my lords, which was not challenged before the learned single judge, my lords. And thereafter,
question is, the qualification must prescribed under the rules.
yes, the minimum qualification is there, my lords. The rules only prescribe the minimum qualification. Rule does not lay down that the state government does not have a discretion or it is the only qualification, my lords. Had it been the case, my lords, where the rules provide that the person is only that person is eligible who possess a diploma, my lords, then the opinion of
the rule says equivalent.
Minimum.
Advertisement says equivalent.
My lords, may I just read the schedule once again for a moment?
Yes.
It says for minimum. I'll take my notes to page number 178 for a moment once again.
Yes.
Column number 3. Must have passed secondary examination. Second, a diploma in automobile engineering or a diploma in mechanical engineering provided by the state government. Any qualification in either of the above disciplines declared equivalent to the central government.
Any qualification in either of the above discipline declared equivalent by the central government.
Yes, Manoj. So
equivalent, what equivalent is there?
equivalent is there, Manoj.
So you mean to say the degree is equivalent to diploma?
No, Manoj. What we mean to say, what I am arguing is this, Manoj, that the rule prescribed that the state government or a central government can prescribe any qualification which is required for the minimum.
Yes.
Which is the minimum standard to apply for it, my lords. Now, in this particular case, the state government, by its own wisdom, has taken a call to include the degree holders also because they possess the higher education, my lords.
Got the point. Next.
Now, my lords, on basis of this, kindly have a look at, my lords, the equivalence report of 14/10/2022, my lords.
Yes. Yes, Satpal Reddy. Judgment.
On page number 53 of
Wait a
the
second.
page number 53, my lords, that the equivalence report is reproduced. And that equivalence report, my lords, was reproduced on the direction of a learned single judge, my lords. Page 53. Internal page 17.
17. Yes. Yes.
This is 14/10/2022, my lords.
Yes.
And my lords, first they have recorded that it was prepared on 14/10/2022. Then the quorum of a meeting on page number 54, my lords, they have given a justification that why have they included the higher education, higher qualification.
Yes. Yes.
On page number 18, my lords, have it.
Yes.
My lords has it. I'm reading, my lords, बैठक में मोटर वाहन उप निरीक्षक भर्ती परीक्षा 2021 के अंतर्गत शैक्षणिक योग्यता के संबंध में मैकेनिकल इंजीनियरिंग और ऑटोमोबाइल इंजीनियरिंग के अभ्यर्थियों की पात्रता के संबंध में उपस्थित विषय पर व्यापक विचार विमर्श किया गया। राजस्थान कर्मचारी चयन बोर्ड द्वारा मोटर वाहन उप निरीक्षक भर्ती परीक्षा 2021 के लिए विज्ञप्ति क्रमांक 1600 जारी की गई थी, जिसमें शैक्षणिक योग्यता का विवरण नियमानुसार है। तदनुसार दिनांक 15/12/2021 को राजस्थान कर्मचारी चयन बोर्ड द्वारा संशोधित कार्यालय आदेश की शैक्षणिक योग्यता के संबंध में स्पष्टीकरण जारी करके उल्लेखित शैक्षणिक योग्यता के से उच्चतर शैक्षणिक योग्यता रखने वाले अभ्यर्थी भी मोटर वाहन उप निरीक्षक के पद के लिए आवेदन कर सकेंगे। प्रश्नगत याचिका में पक्षकार अभ्यर्थी द्वारा सड़क परिवहन एवं राजमार्ग मंत्रालय भारत सरकार की अधिसूचना दिनांक 8 मार्च 2019 को उल्लेख करते हुए मैकेनिकल ऑटोमोबाइल डिग्री धारक को पात्र मानने पर उक्त अधिसूचना का उल्लंघन किया जाना बताया है, जबकि तथ्य यह है कि उक्त अधिसूचना केंद्रीय मोटर व्हीकल नियम की धारा के अंतर्गत न्यूनतम अंतर्गत न्यूनतम शैक्षणिक योग्यता का निर्धारण करती है। उक्त अधिसूचना राजस्थान सरकार को मोटर वाहन उप निरीक्षक पद की न्यूनतम शैक्षणिक योग्यता से उच्चतर योग्यता निर्धारित करने से प्रतिबंध नहीं करती है। इसी परिप्रेक्ष्य में राजस्थान कर्मचारी चयन बोर्ड द्वारा शैक्षणिक योग्यता का निर्धारण किया गया है, जो कि उचित है। प्राकृतिक न्याय के सिद्धांत एवं व्यवहारिक दृष्टिकोण से देखा जाए तो किसी भी शैक्षणिक योग्यता का विचार करते समय न्यूनतम का ही निर्धारण किया जाता रहा है। किसी भी पद के लिए अर्हता के न्यूनतम मापदंड ही निर्धारित किया जाना उचित है। निर्धारित से उच्चतर योग्यता धारक अभ्यर्थियों को अपात्र मानना न तो तर्कसंगत है और न ही न्याय संगत है। जहां तक मोटर वाहन उप निरीक्षक पद पर भर्ती हेतु शैक्षणिक योग्यता का प्रश्न है, पूर्व की भर्ती, दिस इज इम्पोर्टेंट, पूर्व की भर्ती परीक्षाओं में भी निर्धारित शैक्षणिक योग्यता को न्यूनतम मानते हुए उच्चतर योग्यता धारक अभ्यर्थियों को पात्र माना जाता रहा है। अतः प्रस्तुत प्रकरण में and then finally, my lords,
where is the report of equivalence committee?
My lords, this was the
where they have discussed that this qualification is equivalent to this. These are subjects taught in this course, and these are the subjects taught in that course.
So that in the letter of 4 September 2015, AICT, the Board of Technical Education.
The same is on record.
The Board of Technical
Education. Whether the same is on record before, whether the letter was there before the learned single judge.
My lords, state as argument.
Whether the letter was there before the learned single judge for consideration with regard to equivalence.
There, financial states of influence.
नहीं, reply तो सबका same था, आप भी थे।
We were not party.
अरे भाई कोई बात नहीं, आप पार्टी नहीं थे, all right.
So after the equivalence report of 14/10/2000,
not equivalence report.
I go down to that, my lords. I asked this question to myself, my lords. If the learned single judge directed
equivalence report, आपने यूनिवर्सिटी को भी केस किए होंगे, उसके अंदर आता है कि
the syllabus of this subject, syllabus of this subject. I go down to that, my lords. My humble submission is
because the advertisement says, the rule says that equivalent, as prescribed, equivalent. Word equivalent is there. Where is that? That is missing.
My lords,
अभी दोबारा देख लेते हैं भाई रूल की पोजीशन। एडवर्टीजमेंट एंड रूल दोनों को 2-4 बार ही पढ़ा ना, अपने क्या जल्दी है?
The advertisement, my lords, in my humble submission will be read with a corrigendum because
कोई बात नहीं, corrigendum.
So advertisements.
अरे भाई ठहरो, corrigendum कोई रूल के अगेंस्ट थोड़ी जाएगा।
Yes, it cannot, my lord.
Any qualification in either of the above disciplines declared equivalent by the central government or the state government.
That is, my lords, only with respect to the minimum qualification required, my lord.
Equivalent word बता दीजिए आप। the equivalence report was not placed before the learned single judge by the state government, deliberately or non-deliberately, but the same was not before the learned single judge.
The learned single judge act in
एक तो हो गया, अब नहीं है ना रिकॉर्ड पे
सर 14/10/2022 रिकॉर्ड पे है.
equivalence report learned single judge के सामने नहीं थी. We will not consider. Next. What is your next argument?
Now, minus vis-a-vis. Kindly have a look at this judgment matters of Jyoti KK versus Kerala Public Service Commission.
एक मिनट देखते हैं.
This is 2013 3 SCC.
Yes, next judgment.
I've got my copy.
बता दीजिए भाई.
This is my lords Jyoti KK versus KPSC.
Jyoti KK
versus Kerala Public Service Commission.
versus Kerala Public Service Commission. 2010
15 SCC 596.
596. Yes.
Now, my lords, may I take my lords to para number 7 in this case?
Para 7. Yes, para 7.
It is no doubt true. May I read, my lords?
Yes.
It is no doubt true, as stated by the High Court, that when a qualification has been set out under the relevant rules, the same cannot be in any manner withheld down and a different qualification cannot be adopted. The High Court is also justified in stating that the higher qualification must clearly indicate or presuppose the acquisition of a lower qualification prescribed for that post in order to attract that part of the rule to the effect that such of those higher qualifications which presupposes the acquisition of a lower qualifications prescribed for the post shall also be sufficient for the post. If a person has acquired higher qualification in the same faculty, such qualification can certainly be stated to presuppose the acquisition of a lower qualification prescribed for the post. In this case, it may not be necessary to seek for under the relevant rules for the post of assistant engineer, degree in electrical engineer of Kerala University or other equivalent qualification recognized or equivalent thereto has been prescribed. Same language of the rule is there, my lords. For a higher post, when a direct recruitment has to be held, the qualification that has to be obtained obviously gives an indication that such qualification is definitely higher qualification than what is prescribed for the lower post, namely the post of sub-engineer. In that view of the matter, the qualification of degree in electrical engineering presupposes the acquisition of a lower qualification of diploma. In that subject, prescribed for the post shall be considered to be sufficient for that post.
Yes.
In that event, the government is of the view that only diploma holders should have applied to the post of sub-engineers, but not all those who possess higher qualification. Either this rule should have excluded in respect of candidates who possess higher qualification. This is what I was arguing, my lords.
Yes.
Because the rule only prescribes the minimum qualification, does not exclude the higher qualification. And what Honorable Supreme Court says, para number 8, under the relevant rules for the post of assistant engineer, degree in electrical engineering of Kerala University or other equivalent qualification recognized or equivalent thereto has been prescribed.
Yes.
For a higher post, now
degree in
electrical engineer,
yes,
has been. For a higher post, when a direct recruitment has to be held, qualification that has to be obtained obviously gives an indication that such qualification is definitely higher qualification than what is prescribed for the lower post, namely the post of sub-engineer.
Yes.
In that view of the matter, that qualification of degree in electrical engineering presupposes the qualification of a lower qualification of diploma. As in this case, in that subject prescribed for the post shall be considered to be sufficient for that post.
Wait. 178. Their posts were different. The higher qualification was treated equivalent for the lower post also.
Yes. So what Supreme Court said that when higher qualification is treated, it presupposes that the person has a minimum qualification.
Yes.
Now kindly see, Manoj, what Honorable Supreme Court said in para number 9.
Yes.
Even the government is of the view that only diploma holders should have applied to the post of sub-engineer, but not all those who possess higher qualification. Either this rule should have excluded in respect of candidates who possess higher qualification, or the position should have been made clear that degree holders shall not be eligible to apply for such post.
Yes.
When that position is not clear, but on the other hand, rules do not disqualify per se the holders of a higher qualification in the same faculty, it becomes clear that the rule could be understood in an appropriate manner as stated above. In that view of the matter, the order of the High Court cannot be sustained. In this case, we are not concerned with the question whether all those who possess such qualification could have applied or not. When statutory rules have been published and those rules are applicable, it presupposes that everyone concerned with such appointments will be aware of such rules or make himself aware of the rules before making appropriate application. The High Court therefore is not justified in holding that the recruitment of appellants would amount to fraud to the public.
Yes.
We must notice that one aspect of the matter, the diploma holders who had been selected by Public Service Commission have already been appointed, and therefore it would be not be appropriate to disturb their appointments, and they shall continue in such appointments. Such of those eligible degree holders who fulfill the qualification referred to above and found suitable to be appointed shall be appointed, taking note of the vacancies which are available within the period of 3 months from the date of receipt of this order. So my humble submission is this, my lord, as I was arguing in the first limb of my argument, that the rule only envisages the minimum qualification. If a state government in its own wisdom prescribe a higher qualification by virtue of a corrigendum which is issued last date of an application form, my lords, by their own wisdom they have prescribed a higher qualification which presupposes a minimum qualification. It is not a case where they have blocked the door and they said only diploma people are allowed, my lords. Those people who possess a higher qualification, those candidates presupposes a minimum qualification. With that pretext, my lords, the order of 15/12/2021 was passed, my lords,
Yes.
and accordingly the Equivalence Committee declared that the degree holders are also eligible to participate in the examination. To that extent, what learned single judge has done after that, kindly appreciate for a moment, learned single judge has only simply gone on the fact.
Where is the order passed by the learned single judge for constitution of Equivalence Committee?
That was passed, my lords, on
Reproduce किया होगा ना?
yes, my lords, page 17 of the judgment, my lords.
17.
So 20th September 2022.
17.
Yes, sir. Sir, in the writ tip, in the order sheets of the writ, it is 20th September 2022, sir, order.
My lords would find on para number 8 for a moment. Para number 8, page number 16, internal page number 16.
60.
16, my lords. 16. And my lords, I am reading 5 lines from the bottom of the page.
Yes.
Therefore, on the prayer of petitioners and following the circular of DOP dated 18/10/21, this court-wide order dated 20th/9/2022 directed the Secretary of DOP
Yes.
to place the matter before the Equivalence Committee to be constituted in persons of the circular 18/10/2021 for judging the eligibility of the candidates
Yes.
who are having a degree in automobile and mechanical engineering for appointment to the post of motor vehicle sub-inspector pursuant to the and then Manoj, the report is reprinted.
Yes.
So my humble submission is this, Manoj. This report has considered that fact that earlier also it is a practice of a state government to include these degree holder candidates because they presupposes the minimum qualification of diploma holders, Manoj. However, what learned single judge has committed an illegality, Manoj, kindly appreciate for a moment.
Yes.
Manoj, on page number 48, the internal page 48 of the judgment, Manoj.
Yes. 48. Yes.
The reasoning given by the learned single judge, Manoj. In the present case, it is not in dispute that the state government has not prescribed the qualification of degree in automobile mechanical engineering, being higher education qualification is eligible. Education treating the same as equivalent qualification to the diploma in automobile mechanical engineering in the advertisement dated 24/11/21 issued to initiate the present process of direct recruitment to fill vacant post of MVSI. It is also true and cannot be disputed that the qualification of degree in automobile mechanical engineering, despite being higher qualification to that of diploma, is not prescribed under Rule 11. This is the reasoning given by learned single judge. Schedule 1 of the rules of 1963 for the post of MVSI. However, the state government has supported the office order dated 15/12/21 issued by the RSSB and has taken a stand in the reply to contested petitions that in the previous recruitment process of MVSI 2013, the Rajasthan Public Service Commission seeks guidance from the Department of Higher Qualification, and it was informed by the department on 4/9/2015. Manoj were asking about that circular where it was considered by learned single judge or not.
Yes.
It was informed by the department on 4/9/2015 that the candidates having higher qualification